Good day. We are the Group 7 of 2HR1 and we're going to present our video case digest, GR number 171460, Mercado versus Allied Banking Corporation. I am Nicole Ercirio and together with me is Ms. Danica Cunanan. The petitioners are the heirs of Perla and Mercado, and the respondent is the Allied Banking Corporation. For the first fact, Perla executed an SPA in favor of her husband, Julian D. Mercado, over several pieces of real property registered under her name, authorizing the latter to perform the following acts. First is to act on her behalf to sell, alienate, mortgage, lease, and deal otherwise over the different parcels of land. Two is to sign on her behalf any act of strict dominion or ownership. Third is to exercise any or all the acts of strict dominion or ownership over the above-mentioned properties, rights, and interests therein. Next is, on the strength and the aforesaid SPA, Julian obtained a loan from the respondent in the amount of 3 million pesos. Still using the subject property as security, he obtained an additional loan from the respondent in the sum of 5 million pesos. It appears, however, that there was no property identified in the SPA as RT 18206 and registered with the Registry of Deeds. What was identified in the SPA instead was a property different from the one used as security for loan. Now, Julian defaulted on the payment on his loan obligations. Thus, the respondent initiated extrajudicial foreclosure proceedings over the subject property, which was subsequently sold at public auction, and the respondent was declared as the highest bidder. Now, the petitioners initiated an action for the annulment of REM, constituted over the subject property on the ground that the same was not covered by the SPA and that the said SPA at the time the loan obligations were contracted are no longer had force and effect since it was previously revoked by Perla. In the absence of authority to do so, the REM constituted by Julian over the subject property was null and void. Thus, the petitioner likewise prayed that the subsequent extrajudicial foreclosure proceedings and the auction sale of the subject property be also nullified. Here are the issues. First is whether or not the real estate was entitled to legal mortgage. Second, whether or not there was a legitimate SPA revision. Third, if the respondent, a mortgagee, acted in good faith or not.
Ruling. In the case at bar, it was Julian who obtained the loan obligations from respondent which he secured with the mortgage of the subject property. The property mortgage was owned by his wife, Perla, considered a third party to the loan obligations between Julian and respondent. It was thus a situation recognized by the last paragraph of Article 2085 of the Civil Code that third persons who are not parties to the principal obligation may secure the latter by pledging or mortgaging their own property. There is no question, therefore, that Julian was vested with the power to mortgage the pieces of property identified in the SPA. However, the subject property was not among those enumerated therein. Julian was not conferred by Perla with the authority to mortgage the subject property under the terms of the SPA. The real estate mortgages Julian executed over the said property are therefore unenforceable. The said SPA was revoked by virtue of a public instrument executed by Perla to address respondents' assertion that the said revocation was unenforceable against it as a third party to the SPA and as one who relied on the same in good faith. The rule is that an agency is extinguished, among others, by its revocation. The Register of Deeds of Quezon City was not notified that any attempt to mortgage or sell the property was covered by TCT number 106338 must have the full consent documented in the form of special power of attorney duly authenticated at the Philippine Consulate General, New York City. The palpable difference between the TCT numbers referred to in the real estate mortgages and Julian's SPA, coupled with the fact that the said TCTs are registered in the registries of deeds of different cities, should have put respondents on guard. Respondents' claim of prudent is debunked by the fact that it had conveniently or otherwise overlooked the inconsistent details appearing on the face of the documents, which it was relying on for its rights as mortgagee. And which significantly affected the identification of the property being mortgaged. Moreover, the respondent is a mortgagee bank and is expected to exercise greater care and prudence in its dealings, including those involving registered lands. The property secured by the loan should be determined before proceeding with the loan. There must have been a caution in processing transactions, especially in this case that Julian was not the owner of the land. The court found that the real estate mortgage over the subject property be unenforceable and null and void. It is not enforceable by a proper action in court because of defects provided in law unless they are properly ratified. Thank you and God bless.